Okay, Jay Spear, Executive Director of the Poverty Law Center, and welcome to our 2026 General Assembly first day coffee chat. I will give a very, very brief introduction, and then you're going to hear from all of our different advocates, and we're going to run through a PowerPoint so you can look at something while they're talking, and we're going to give you just the bare bones of a lot of different issues and only a very small portion of all the issues we work on, but ones that we think folks will be interested in. As an introduction, let me just say that we really encourage people to get involved. And one way you can do that is go to our brand new website, vplc.org, and click on the link that says Get Involved and give us your email. And you can get on our newsletter. That's one way. A second way is to respond when we send out things called action alerts, which is basically says a bill is coming up before a committee tomorrow. Please email your legislator and tell them to vote yes or no. A third way is to get to know your legislators. I really try to preach this a lot to people. Get to know your legislators. Let them hear from you. It's unbelievable how important it can be for them to hear from folks about issues. It makes quite a difference. Even better is if your legislator knows you, and that's not something you can get to know them by talking to them pretty much during the off season for the most part. But I think it's really important for folks to do that. And I also try to stress to people, not every contact with your legislator ought to be negative. And, think about ways you can say, thank you, Delegate so-and-so, for voting yes on this bill. We really appreciate it. It's going to help a lot of people. And then the fourth way is to get to know the issues. And that's what you're doing today by getting on this coffee chat. I also would point out a couple other things that we have a VPLC YouTube channel where you can look at a really good, what I think is a very good, for those of you not familiar with how the General Assembly works, it's a very good overview of how it works, how the process works. I think it's called What You Need to Know About the General Assembly. Let me know if you can't find it. And we also have now, Valerie and Amanda did a session earlier this month called Advocacy 101. That's also a good thing to look at about ways you can advocate. There's going to be a ton of bills at the General Assembly, as there already are. I think there's like 1,200 bills already introduced, and there'll be more. That doesn't even include the resolutions and the budget. So let's get on with it. And can you advance the slides, somebody? Yeah, this is just some other things that we do besides advocacy. Go ahead, next one. These are the folks that advocate for us at the General Assembly. I think there's 15, if I'm not mistaken. And we all have different issues that we work on, some together. And if you ever have any questions, feel free to email us. There's everybody's email. It's pretty much everybody's first name at vplc.org, except Daniel, and that's because we have two Daniels on our staff. Next. Go ahead, Christy, I think you're up.
Okay, thanks, Jay. Good morning, everybody. There are a lot of exciting things happening in the affordable housing space this General Assembly session, so I'll just try to highlight a few of them. But if this is an area you're particularly interested in, feel free to reach out to me. So we are looking at a number of bills that will be putting some limits on the ever-rising costs of rental housing. And two of them actually deal with the costs incurred when you're applying for rental housing. Delegate Elizabeth Bennett Parker has a bill that, among other great things that it does, it requires landlords to charge only one application fee, even if the tenant is applying for multiple units that they have. And we know, especially with larger landlords, these corporate landlords might own 2 or 3 apartment complexes. And right now, if you're applying for each one, you're paying a separate application fee, and that can be quite costly. So this is a great way to limit those costs. And then Senator Van Valkenburg also has a bill that limits the amount that you would have to pay for an application fee and for an application deposit. That bill also significantly limits security deposits to 1 month's rent. Right now, a landlord can charge up to 2 months' rent And the average rent in the Commonwealth right in 2025 was over $1,800 a month. So right now, if they want to, a landlord can charge 36, as much as or more, but an average of $3,600 just for the security deposit alone. So we're really very supportive and hopeful about the bill limiting that to 1 month's rent. And then there are bills in the House and Senate to require better notice of a rent increase when the lease renews. Right now, landlords can give that notice of a rent increase the same day that the tenant has to tell the landlord whether or not they want to renew. So that's not very helpful. This would change that and make sure tenants had adequate time to evaluate whether they wanted to renew once they got notice of that rent increase. And of course, we're working with Delegate Clark and Senator Boysko on a bill that would allow localities to set rent caps. And I just want to say that bill has a lot of protections for landlords, including what we call a fair rate of return provision, which says that if a landlord can show that abiding by the rent cap would not provide them with a fair rate of return, they would get an exemption. And then finally, in the affordability area, there is a bill that will be going in to limit a lot of these extra fees that we're seeing the larger landlords charge for things like maintaining HVAC systems or maintaining common areas that by law really are the landlord's obligation. So we're seeing a bill to expressly limit those fees. And that's it on that slide. We also hear an awful lot about really, really bad housing conditions. The picture you see there is really representative of what we hear from a lot of tenants living in lower rent, unsubsidized units in some of our older cities. And so there are two bills that we're really excited about, both of which have passed in the past, but did not make it past a gubernatorial veto. One would remove the barrier of having to be current on rent in order to sue your landlord for not making repairs. And the other one expressly gives local governments the power to sue landlords who aren't making repairs under the Residential Landlord Tenant Act, which has a lot of really good remedies that they cannot get if they're just bringing a code enforcement violation case. I'm trying to go really fast. Next slide. And then, of course, we're still working on eviction prevention. Our eviction rates, though they are at about 80% of where they were back in 2019 when we were outed as the state with the highest eviction in the nation by Professor Desmond and his eviction lab, they're still much, 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 much too high. So one of the keys, and we've been working on this for years, and a big shout out to Delegate Sia Price for working with us for so many years on this, is to give people more time to pay their late rent and late fees before the landlord is allowed to sue them. Once they're sued, in addition to the late fee and the past due rent, they then have to reimburse the landlord for court costs and sometimes for some attorney's fees, sometimes for some very extreme attorney's fees as well. So we want to give the tenants time at the front end before the landlord has to even go to the trouble of suing them. The Virginia Eviction Reduction Program, which has been around since 2020, is very successful. This is a program, it's a grant program that provides funding to local and regional nonprofits to use any way they see fit to help their community members stay stably housed. That's been a very successful program in reducing evictions, and we're looking to increase at least double the funding for that program. We're also looking to implement something called a warranty of habitability defense in non-payment of rent eviction cases. Right now, we have the illusion of such a defense, because if a tenant pays all their rent into court, then they can raise unsafe housing conditions as a defense in a non-payment of rent case. Well, I can tell you pretty much 0% of tenants who are being sued for non-payment of rent are able to pay their rent into court. So that defense really isn't very helpful. This the bills we're working on this year with Delegate Carlson and Senator Boysko would remove that requirement that the tenant have paid all their rent into court and allow them to just raise the defense of the landlord not living up to his obligation to keep the house safe and habitable, and let the judge decide what to do and whether to lower the rent. And then finally, there's a bit of our code that provides some protection to domestic violence victims who are the victims of criminal violence on the premises. Normally, if there's criminal activity in your unit, you can be evicted for that. We have a law that says if that criminal activity was directed at you and you're a domestic violence survivor, you have a bit of protection, but that protection is pretty weak. And so we will be working with folks on a bill that would strengthen domestic violence survivors' protection against eviction in those circumstances. And I think that might be it for housing. Next slide, please. Sorry, I don't.
Christy, you do have two questions in the chat, and since
I'm sorry. I
since you
wasn't
did
monitoring
finish ahead of your time schedule, we can go ahead and take those really quick.
Sure.
The first one was, does the bill provide a private right of action for violations of these rights?
Which bill? I'm sorry.
It was like on the first slide. Kevin, if you want to unmute and ask the question, you can.
Sure. Yes. Hi. There was regarding the first slide about caps on application fees, security deposits, things like that.
I did not write that bill, and so I will look at that and get an answer for that. Yeah, I'd have to look. I don't remember off the top of my head. There are two different bills that do that, and I will get you the answer. I'm sorry about that. What was the other question?
How would the bill define fair right of return? And that was Alexander. If you want to.
Fair right of return is sort of a term of art. I don't know that the bill has a specific definition of it, but it is a term of art in this area. I believe it's also an accounting term. And so while I don't believe the bill expressly defines it, it is a term of art. And so there is a common definition. Oh, sorry, one more housing slide. We are working with some other groups, to Legal Aid Justice Center, New Virginia Majority, and the Fairfax NAACP to once again try to get residents living in manufactured home communities and the locality in which the community is situated a right of first refusal to purchase their manufactured home community if it is at risk of being sold. So the way this would work is if the owner of a manufactured home community gets an offer to purchase that community, the owner has to give notice to the residents of the community and to the locality. And then the locality has a certain period, and the residents have a certain period of time to make a substantially equivalent offer. And that offer, if it is substantially equivalent and offers to buy the park for the same price, takes priority. And then we have several tweaks that we're making this year, or trying to make this year, to the Manufactured Home Lot Rental Act to strengthen protections for residents of manufactured home parks. There will be a more comprehensive bill amending the Manufactured Home Lot Rental Act in 2027, and this is really a preview of that bill.
Sushila, Sushila or Valerie?
I was waiting for Valerie to start, but how about I do the domestic violence ones, which are bullets 2 and 3. I'm Sushila, everybody. I'm the domestic and sexual violence attorney at VPLC and our Center for Family Advocacy director. So in family abuse protective orders, there's a lot of relief that's available to survivors, because of the intimate partner violence dynamics. The only listed out type of financial support is child support. So often that means that judges feel they cannot issue another type of financial support, like help with utilities or temporary spousal support, et cetera, until the parties split if they're divorced, et cetera. So this would be to add that protective order relief, like a box on the form. And then the second one, lifetime protective orders. So what this is, basically in Virginia, we don't have, even though they call them permanent protective orders, we don't have those. We have 2-year protective orders. In certain circumstances, you can get an up to 4-year protective order if the abuser already has a protective order against them. But with violent felons who've been convicted of that violent felony, the idea, and this was passed a couple of years ago, is that why should the victim of this violent felon have to keep coming back every 2 years to ask for a protective order they're going to get? So that was the discretion given to judges to issue lifetime protective orders in certain circumstances. But what ends up happening is that they're only used after conviction. So when there's plea bargaining, negotiations going on, charges are pled down, and this doesn't become available. So I would like to expand the availability of that type of lifetime protective order. And then a couple of things related to all of our issues that are not on here. We, Virginia Poverty Law Center, are working with a number of other organizations, the Commonwealth Institute, Voices for Children, and the Hamke Center, with Delegate Tran, to increase money for language access, especially at 18 public-facing state agencies. So that would be language access coordinators, even looking at the vendors that Virginia state agencies use for translation and interpretation. So we're hoping to get some money in the budget for that. And then my colleague organization, the Action Alliance, they are the coalition of all the advocates and shelters in Virginia. As you probably know, with federal cuts and restrictions on funding, many domestic and sexual violence advocacy programs have lost funding. So they're asking for $6 million in the budget. And that's it for me. I'll pass the mic to Valerie.
Thank you, Sushila. I'm Valerie LaRue. I am the Deputy Director of the Family Advocacy Center, and I work on family law and child welfare issues. So our biggest priority is always keeping children with their families so children don't suffer from the harms of separation and being placed in foster care. So our big bill to do that will first of all, define for the first time under Virginia Code what reasonable efforts means. And reasonable efforts are what the child agency is supposed to do to assist the family and the child to reunify. And to prevent removal in the first place. So they're supposed to provide services that will help keep the child safe at home or return the child home if they do remove the child. So we borrowed the Indian Child Welfare Act definition of active efforts to describe what reasonable efforts are. The Children's Ombudsman report indicates that while some local agencies are providing basically active efforts, others are providing really almost no efforts at all. So this will hopefully ensure that families across the Commonwealth get the same level of services. Another thing the bill does is tries to correct a historical injustice relating to Native tribes in Virginia. So Virginia has some of the oldest recognized tribes in the country that are recognized by the state of Virginia. But for many decades, while other tribes in other states were being recognized by the federal government and having access to federal grants and federal supports, Virginia tribes did not, and that was because of the Racial Integrity Act that Virginia passed back in the 1920s and 30s, and which was overturned in Loving versus Virginia. But that act made it so that it was very hard for people of Native American descent to maintain their Native identity because a lot of times they were not allowed to put Indian on their children's birth certificates, and instead they were just listed as Black. And so that when rules around federal recognition came along, that made it really hard for many of Virginia's tribes to prove that they were in fact tribes. So Senator Warner and Senator Kane have worked with the tribes and with the federal government to help them. So Virginia right now has 11 state recognized tribes, 2 tribes that are seeking state recognition, and 7 tribes that have federal recognition. So under the Indian Child Welfare Act, only the 7 children who are members or eligible for membership of the 7 tribes are able to get the services provided under the Indian Child Welfare Act. So this bill would also tell local departments that they need to provide that level of services to children of families of the other tribes, the 11, whatever, 7, 4 other tribes that are not federally recognized to receive that same level of services. And it also provides for some more guardrails around some of the court processes and things like that. We're also working with, there are 2 competing bills, one from Senator Locke, one from Senator Favola. We're working mostly with the Locke bill. We prefer that one that sort of clarifies the processes and procedures around when infants are born to mothers with substance use disorders and those kinds of situations. And then finally, we've been working now for a very long time at VPLC on improving legal advocacy for families and child welfare matters. And you may remember a couple of years ago, we were able to get a bill passed that increased the amount of money that panel attorneys are paid, and then also created standards of practice for such attorneys and specialized training for such attorneys. But across the country, the standard of practice in this practice area is what's called the multidisciplinary model or holistic model. And the bill that we got passed 2 years ago allows for up to 2 pilot projects for that model in Virginia, and Roanoke has been working on for the last year on developing such a pilot. And so we are going to be supporting a budget amendment to fund that pilot and bring that model to Virginia finally. That's it.
Again, it does not appear that there are any questions on that, so I will turn it over to Emily Hardy.
Hi, all. Sorry for my voice. I'm recovering from a cold, so I might go a little bit in and out. Obviously, Medicaid and healthcare benefits have been in the news this past year, so we are focused very closely on trying to protect those programs. For health coverage, unfortunately, under federal law, a lot of the changes that happened in HR 1 this past year, there isn't that much the state can do about it. So what we focused on is trying to bring forward the pieces where the state can expand the types of coverage we provide or the people we provide to offset cost cuts. And some of those are going to be focused on immigrant populations, which there were large-scale cuts for legally residing immigrants and what health coverage they had available. So there are some places where Virginia has been more restricted than federally required. And so we are seeking to expand those areas of coverage to offset these cuts the best that we can. We are also looking at just making sure that there's sufficient funds in there because there was the fiscal impact that came out and the estimates show that we did not have enough funding for Medicaid to actually deal with the costs that were coming without even looking at HR 1 cuts, which is going to cut the way in which we bring money into the program. So there were some suggestions on how to do it that came out in the governor's budget that came out under Youngkin's administration. We agree with some of those, but we will be pushing back on some of them as well and making sure that cuts that happen in the program are not cuts to services that people rely on, but instead are looking at ways to reduce sort of waste of money that we have, whether that is making sure that managed care is operating efficiently and things like that. So really, we're trying to make sure to retain services for individual people, retain coverage for individual people, and make sure that any cuts are being done in an accurate way, and that they are actually trying to cut out things that should not be, that are cost waste, I guess, if we're going to use the terminology that's kind of everywhere. Focusing again on sort of trying to protect the individual person's rights. We are trying to expand the appeal timelines so that individuals can appeal up to 90 days when there's an eligibility determination that denies them coverage. This is because a lot of people are going to now face every 6-month renewals rather than once a year. So it's going to be double the amount of work at locals, which means there are probably going to be an increase in errors and mistakes made. So we want to make sure that individual people and that the impact is reduced as much as possible. We also know that there have been changes at the Postal Service. We have seen large delays in mail for the past 4 years since the original Trump administration changes to the Postal Service. Those haven't gone away in the past 4 years. And we are also seeing additional changes. They're no longer going to timestamp mail timely. They're no longer going to guarantee, that they've timestamped it if you've dropped it off and things like that. So we are trying to address those changes. Sorry, I don't think that chat's related to me. So we're trying to address those changes as well so that individuals who file an appeal can rely on the fact that putting it in the mail does mean that they get this right to appeal. So some of our bills are focusing really on those appeal rights for individuals to resolve it. For several years, we've also been trying to fix the Administrative Process Act, which is where someone has done an administrative hearing, lost it, and then tried to go to court to try to get the correct answer. And so we are continuing to push to resolve that and make Virginia's law clear that someone has the right to a full review of their case if they bring it to circuit court. The way Virginia's law is written currently, it does not treat low-income people the same as everyone else for those rights at circuit court. So again, these are sort of focused on trying to reduce those individual harms where the duplication of, doubling the amount of paperwork someone has to do, the amount of renewals, that all of those things can be fought back against on the individual level, and then as well as pushing to try to keep as many people covered as possible. For SNAP benefits, they changed the amount the state has to pay in order to maintain our program for the administration of the program. So it used to be, I think, a 50-50, and now it's that the state has to pay 75% of administration costs. There's also going to be increased costs to the state for the first time for the actual benefit coverage. That is not coming till later. I believe it's coming in 2027, but it's going to be based on our error rate. So we are focused on making sure that the state puts adequate funds to maintain the program so that low-income people are not the people that suffer due to these changes. So first, making sure the administration is fully funded, which it was not in the governor's budget, and then working to address the error rate to try to reduce it so that the state pays as little as possible of this, as well as just making sure that those funds are allocated, because otherwise the person that loses the benefit is obviously going to be a low-income person. We don't want the harm to fall on them. We continue to support free school meals for all students. I believe it's focused on breakfast at this time in order to reduce costs, because if you bring both meals, it's obviously a much higher expense, and the state is facing a budget crisis. And so we are working in coalition on that issue to try to make sure that kids in school have food and access to food. And that's obviously even more important when we're seeing all of the pressure from these cuts and the anti-immigration rhetoric that is leading to some mixed status families dropping benefits and dropping access to services like food. So making sure that kids can at least get a meal at school if they have lost access to other services. Reducing utility costs and preventing destabilizing service disconnections. I don't know if someone from Economic Justice has specifics on that one, but I do know that we are obviously continuing to work within the utility space. So happy to pass that off if someone wants to speak on that now, or we can talk on it later. Okay, I'll keep going and then assume that Economic Justice will cover it. And
yeah, we'll cover it during Economic Justice, Emily.
Okay, sounds great. Obviously, LIHEAP and other programs also fall within the benefit programs. And so there are things that we work on as a group, but Economic Justice takes leads on those. So I'm happy to pass it off at that time. And then nursing home care, we've worked on for a really long time. There was a nursing home staffing standard passed in 2023. There were then federal regulations that came into effect in 2024. Our law said that if the federal regulations are in place, our law is not enforceable. And therefore, the actual standard was pulled from code. And when the federal regulations were overturned in April of this year, there had been no movement by VDH on drafting regulations or putting staffing standards in place, despite the fact that they were supposed to go into place as of July of 2025. So we are working with the House and Senate on getting those back into code, looking at emergency regulations and getting staffing standards moved as quickly as possible. Additionally, we're looking at ownership bills to try to keep out bad owners from Virginia. So there are, private equity buying up nursing home facilities, lowering the staffing at those facilities to make profit. And Virginia has very little process at this time to maintain or refuse a license to somebody who comes in but does bad things in other states. So we are working to try to put in place a law that would prevent that kind of action. We are also working on, although not one of these sort of major points, some long-term improvements to things like Medicaid estate recovery, which we had something happen in 2021 that brought that issue to the forefront. And we're sort of returning to that piece to try to clarify how estate recovery operates, to simplify it to the minimum federal requirements, because we had never changed it after the Affordable Care Act passed, and therefore it applied to a lot of people it was not supposed to apply to. So we are also working with that closely with the Medicaid agency, who we believe is in support of trying to fix those things so that people are not scared of getting health coverage. I think that's probably a good broad overview.
Yeah. There are no questions in the chat, and Emily will let you rest your voice. Thank you. And we're moving on to economic justice. I'll let whoever is starting. I guess Joanna, unemployment.
Good morning. I'm Joanna Darkus. I'm a member of our Center for Economic Justice, where I handle issues related to worker rights and consumer rights. To start on the worker rights side, we work in coalition with the Legal Aid Justice Center, the Social Action Linking Together Coalition, with NELP, the National Employment Law Project, and with the Commonwealth Institute for Fiscal Analysis on unemployment issues broadly. This year, we anticipate the filing of 2 bills. They should be dropping tomorrow that will increase our UI weekly benefit amounts by $48. That is to make folks whole, because last year the General Assembly passed a $100 increase to the weekly benefit amount, but the governor amended the provision to reduce the increase to $52. So we're going back for the other 48 in the hopes that we'll have that baseline of an additional $100 of weekly benefits, so that when in the future, when we come back to index that amount for inflation, we'll be starting from a stronger position. And in the meantime, folks will have more money to make ends meet while they're looking for their next good paying job. The other UI bill this session will be focused on making sure that everyone has ample time to find that job. Under Virginia law as it stands, some workers receive as few as 12 weeks of UI coverage, and other workers receive as many as 26 weeks. So there's a bill, we saw this bill last year, to increase the benefit duration for the folks who have only 12 or fewer than 26 weeks, so that there's a standard benefit duration of 26 weeks. We would be joining 10 other states who've already done this. And we know that the way that job searches work out, sometimes it takes 12 weeks to get through an interview process, and then you're waiting, or you're not even through the interview process within 12 weeks. So really hoping that this measure, when it goes to the governor this time, will be signed. Last year, it was amended out of legislation that made it to the governor's desk. So the General Assembly is familiar with both of these measures, and we hope that unemployed workers in Virginia are going to get the additional support that they need, so that they will see more alleviation of financial hardship for whatever the duration of their unemployment is. There are also measures that we're supporting as part of a broader coalition effort, a very grassroots, all hands on deck campaign to raise the minimum wage, guarantee paid sick leave, and paid family and medical leave. And as an anti-poverty organization, looking for ways to make sure that work is one of the solutions, one of the pathways out of poverty, and one of the ways that people can stabilize their finances, and also still work and care for their families, work and take care of themselves, is really important to VPLC. So this is a cross-cutting, how do we make sure that we're lifting up the needs of our low-income clients across the legal aid network, across the state, and making sure that we are working with others to just reassert that these protections are necessary. So those bills are all moving in the House and the Senate, and measures like those that we'll be discussing this year have made it to as far as the governor's desk in the past, and this year we hope that they will be signed. On the consumer rights side, there's some overlap with worker rights. So what we're hoping to do and see this year is that some of the bills that were brought last year that would protect a baseline amount of money in a bank account, or that would protect individuals in Virginia from losing their entire paycheck because they owe taxes, maybe the car tax, maybe a utility lien, that those folks would still have money to make ends meet today while they make a plan to deal with the outstanding debt obligation down the road. So on the tax side, we've seen that historically in Virginia, state and local government tax collectors, or governments, more broadly than taxes, have been able to take up to 100% of a person's paycheck, and they have exercised that power. That makes Virginia unlike every other state in the country. And we've heard from people in Virginia who have been devastated by that practice, and we are seeking to curb it. Fortunately, since last year, the state has voluntarily reduced the amount by which of garnishments that it takes to 25% of any paycheck. And here we're looking at legislation that would put that 25% into statute. So we codify that. And we're hoping to see the same thing for local state tax collection as well, so that no one's going to lose their whole paycheck because the government debt collectors come knocking. Similarly, Virginia already has protections, like in the wage garnishment protections. An ordinary creditor couldn't take 100% of your paycheck. They're limited to 25% or less of your disposable income. With bank accounts right now, we have certain exemptions, but for most of those exemptions, people have to fill out a form, go to court, maybe get a lawyer if they can to help them claim those exemptions. So rather than forcing people to go to court to claim exemptions, to say this money came from a protected source, we're instead asking that the legislature authorize automatic exemption of certain dollar amounts. So the bill that has been filed for this session would do two things to protect money in a bank account. First, it would establish a minimum protected account balance so that the first $1,000 anyone has on deposit in their bank would be protected. It would still be their money even if the bank gets hit with a garnishment order. Now, we would love to see that $1,000 go up. We know that people need the money that's in their bank accounts, and that if their wages are automatically deposited into their bank account and their rent's due tomorrow, $1,000 probably isn't going to cut it for most people. So we do know that $1,000 is better than nothing, but more protection would be even better. So we're going to continue to work to get a modicum of protection for a baseline amount of funds in a bank account. At the same time that the bill does a second thing, which is to better protect benefits that are exempt from collection. So at the federal level, there's a Treasury rule that protects a certain amount of Social Security and other types of benefits that are automatically deposited into a bank account. And here, Virginia's bill would require banks to look at the source of funds, to trace using the electronic codes other sources of funds that get deposited, and also to protect those funds. And that includes, importantly, for this crossover with workers' rights, UI benefits. So under Virginia law, there's a non-waivable exemption for UI benefits deposited in a bank account. And there's no provision in the law at present to automate that protection. Folks have to raise their hand, fill out a form, go to court to get that exemption. So this bill would automate exemptions like that so that people would have baseline amount of funds and that they'd retain access to the benefits that they receive under federal and state law. And these are working in tandem. Some people are, all Virginians aren't workers, but all Virginians deserve the protections of our existing law and the exemptions they've been given. And we know that they need the limited incomes that they receive and the benefits they receive to take care of themselves and their families. And that's what all of these measures seek to do. I'll hand it off after that.
Great. The actual next slide does not talk about utility rights, but I'm going to turn it over to Dana because I know there are some things about utilities that have not been covered yet.
Hi, everyone. Dana Wiggins, Center for Economic Justice. Yes, I can talk a little bit about our utility work. So all of our work on utilities has really been to make utilities affordable to folks. And so a lot of the work that we have done and the work that we are currently doing this session is really to sort of force the conversation around affordability to talk about actual things that are affordable. There are a lot of bills that are out, but we are supporting a couple of bills that are out that really get to the heart of how to make it affordable for people who are struggling to pay the bills right now. So focusing on making changes to the percentage of income payment program, to either expand the program to a larger scope of people as people are having some other benefits cut back at the federal level, making sure that there's enough support for them in the percentage of income payment program option for their utility costs, but also not just expanding the scope, but changing the percentages of the energy burden that they would have to pay. So from 6 and 10% of their income, which for some folks it would be quite high, to 2 and 4%, which is more in line with what the net across the country what we're doing. And then we are also supporting legislators as they're kind of struggling what to do about with LIHEAP funds always sort of hanging in the balance. They are coming in from the federal government, but the amount is certainly less than it had been in years past. And so making sure that they understand what options they have at their disposal with LIHEAP. We hope that LIHEAP will be coming on, the ability to apply for LIHEAP year round will be coming online this year. But as we're waiting on that from the Department of Social Services, helping the legislators understand what can be done, there are a couple of bills that we'll have to deal with that are trying to talk about affordability, but they don't actually deal with affordability. So we'll be trying to sort of make sure people understand what actually can bring affordability to the utility space versus things that are actually going to cost consumers more money. And happy to answer any questions around that. Moving on to some of our other issues, and I don't know if Jay wants to take this. I'm happy to keep going. We are supporting our uniform, sort of supporting the adoption of a Uniform Consumer Debt Default Judgments Act. And this simply requires that debt buyers have to provide proof of the debts that are owed, because there are so many default judgments when people aren't properly notified, but also when they bring lawsuits against people without any proof at all, and people don't really know how to respond, particularly when they are pro se representing themselves. So this is ensuring that when a debt buyer files a lawsuit, they actually have to provide proof that the debt is owed to them. I don't know if you want to say anything else on that, Jay.
Yeah, I just would say this whole issue of fair treatment in our courts, the way that most people in Virginia have contact with the court, other than the criminal system, is through debt collection, which or being evicted. And Christy already talked about eviction issues, and we address a lot of those. But the debt collection issue is a big one for a lot of people. Tens of thousands of people are sued in Virginia every year for a debt. And about half of those are by debt buyers who Dana referred to. And the problem we have is that debt has become a commodity that private equity firms are jumping on and trying to make a lot of profit from. And they buy people's debt that has been charged off by a credit card company at 1 to 5% of what's owed. And then they go after people for the full amount that's owed. And as Dana said, they often don't have the proof. This is a uniform law that tries to address this issue of just massive default judgments being taken in court, and people are not being heard. And the second bullet point there about non-attorney use of cell phones is we have a problem in our general district courts in Virginia where if you don't have an attorney, it's very hard. You're intimidated and kept. You're scared to go to court. You don't understand the process. And then on top of that, in some courthouses, not all, you get to the courthouse and find out you can't bring your cell phone in, which is, if you came on the bus or somebody gave you a ride, then what are you going to do with your cell phone? Or if you may have evidence on your phone that you need to present in court, or you may need to call somebody to take care of your kids because you're running over too long in court. All these different things, and this needs to be addressed. And this is a good bill that was put in. We will support this. The last bullet point. I don't know if Christy, if you're still on, do you want to address that about preventing evictions driven by excessive landlord attorney fees?
Yes, happily. Some of you may know that VPLC released a report in September about excessive attorney fees in unlawful detainer, otherwise known as eviction cases. What happens in these cases is that the lease itself generally will require a tenant who is successfully sued for eviction to pay a certain percentage of the debt owed as an attorney fee, and that percentage is often as high as 25%. With rents being as high as they now are, that can result in the high hundreds or even over $1,000 in additional costs in attorney fees that the tenant has to pay before court in order to have that case, or on the court date, in order to have that case dismissed. And we know that when those fees are paid prior to court in order to have the case dismissed and stop the eviction, there's really very little legal work that is done by the landlord's attorney. At that point, it amounts to basically filing the case in the general district court, which it does not take a lot of time. And so what this bill says, it limits its changes exclusively to those cases in which the tenant pays all of the past due rent, all of the late fees, and prior to the court hearing, it will cap attorney's fees at $50, which seems to us to be very reasonable. We are really grateful to the Trial Lawyers Association for working with us in refining our talking points on this bill, and to, of course, Delegate Hernandez for being our patron. So we're very hopeful about this one. We think it'll make a big difference for tenants being able to what we call redeem, pay their rent before the first hearing. I'm sorry.
I think, yeah, that's all we had on that.
Okay.
That's
Okay.
Okay, well, I think I scared everybody into staying on a time limit. So we actually have 8 minutes for questions. So good job, everyone. And if anybody has a question, you are free to unmute and ask it. There's none in the chat, so I don't see any hands. I'll just do a quick housekeeping. We will send out the PowerPoint. Oh, Mary Horner, you are welcome to ask.
Sorry, didn't mean to extend. I did a quick question. Had there been any conversations? I know we might be getting ahead of ourselves, but I did see the anti-rent gouging legislation had been proposed. Has it been dropped? Is there any thought of pairing that with just cause eviction? Because I am wondering if what we would potentially see is if this were to pass and then adopted locally, that there would be an increase in non-renewals.
Yeah.
Because then that's the way to get kind of people
Yeah.
out, so we can start, landlords can then start again with a new tenant at a different rate. So I'm wondering if we're considering that.
Actually, Mary, the anti-rent gouging legislation addresses that because it says it doesn't matter if the unit is occupied or vacant. The same rules apply. So
Okay.
it's an annual change. It's not, you don't get to change in the middle of the year what your rent is just because you're changing tenants.
I see. Got it. Okay.
That I've worked, talked real closely with Larissa and others at Legal Aid Justice Center who really worked on crafting this legislation. I know that's the intent.
Right.
And I think the language accomplishes that. So,
Got
but
it.
on good cause eviction, since you brought it up and since we have 7 minutes left, the what we're calling our manufactured home skinny bill, because the big long bill will come next year, that Delegate Krizik has already introduced for us, I believe it's House Bill 374, includes a good cause requirement for lot lease renewal. Right now, it's super confusing in the Manufactured Home Lot Rental Act as to whether or not you have a right to renew your lease every year. This clarifies that, yes, you have a right to renew your lease every year, your lot lease, and the park owner cannot non-renew you unless the park owner has grounds to evict you. In other words, you have violated a lease term or the law. So that's going to be an uphill battle, but that's our first attempt at getting a good cause eviction rule.
It's exciting. Thanks, Christy.
Unless I'm not seeing any other hands, but if you do have it, I will start the housekeeping notes again, and please raise your hand if you have a question. But we will send out the PowerPoint. Eric, go ahead.
Yes, I was just curious how the job loss in Northern Virginia has affected poverty and unemployment and benefits for people in throughout Virginia, but obviously what the impact of the federal government's actions have been.
It's Joanna. I'm happy to just hop on and say that both chambers of the General Assembly convened committees to take a deep dive all year of 2025 and look at what the impact of the federal workforce changes and policy and funding changes were on Virginia. So we followed the numbers, and we're still trying to get additional data about which federal workers have been dislocated, which federal contractors have been dislocated, and who else has been affected, because we know that the private market also and the nonprofit sector are seeing losses as well. So we see that we don't have perfect numbers or perfect information, but we do follow along as the numbers come out from BLS or as Virginia provides them to us. So it's definitely one of the things about unemployment protections and insurance is that during economic downturns and when there are a lot of layoffs, those are usually the times when we have the biggest opportunity to make improvements to our safety net programs. So we hope that we can, while people are struggling, we can find better ways to serve them. And in the short term, both including better connection to job search resources, including for workers that aren't normally served by our unemployment system and our workforce system, but also that we can make sure that the monetary benefits, the UI monetary benefits, are also commensurate with what people were making before they became unemployed and what they will hopefully be making when they rejoin the labor force.
On the healthcare side of it, we have seen increased enrollment in Medicaid expansion for individuals who lost their job. And we also know that the HR1 cuts, which say that if you haven't worked prior to enrollment, mean that, moving forward when those rules go into place for work requirements next January, that future cuts to jobs means people won't have backup health insurance for Medicaid expansion the same way that we do at this time prior to the cuts coming into place. So some push for policy on that issue is to expand subsidies for Virginia's marketplace to try to cover people who we know won't be able to get on Medicaid expansion in the future due to the upcoming work requirements from HR 1. So basically they said, if you are trying to get in to Medicaid expansion because you've lost a job, you must have had a job within the month prior to enrollment. Sometimes people don't realize that they need to apply for that. They think they'll get another job with employment insurance, or they just don't realize their insurance is cutting off. And so they don't get in within that 1 month period. So we are expecting, come this upcoming January when work requirements are in place, that will be a barrier moving forwards for people who lose jobs to be able to get any kind of healthcare afterwards. So supporting expansions of subsidies in the marketplace, because if you're eligible for Medicaid expansion, you currently can't get federal subsidies. So it's sort of a two-prong bar to get healthcare if you lose your job.
And on the eviction prevention side, there is a lot of concern among all of the legislators and the advocates about the fact that up in Northern Virginia, where we do have a lot of folks who became unemployed because of the cuts in the federal government and grant cuts to different agencies and nonprofits who were based up there, that is compounded by the fact that our primary rental assistance program, the Virginia Eviction Reduction Pilot Program, does not have any grantees, and therefore none of those funds go to Northern Virginia. And so we are asking for a significant increase in that program, and partly in recognition of the federal layoffs going from a $3.45 million appropriation a year to a $10 million appropriation a year. And those budget amendments will be introduced by Delegate Krizik and Senator Boysko. And I know that one of the things we will be pointing out as we advocate for that is that this funding would allow the program to actually expand in geographic scope and hopefully serve, or almost certainly if it expands in geographic scope, serve Northern Virginia as well.
Okay. And now we are officially at time. We've used it all up. So congratulations. Housekeeping, you will receive an email with the slides and the link to the video. So please feel free to share it. Final slide is Jay's our website and how to contact us. So thank you all for joining and have a great day.
Thank you.
Thank you.
And